Hi everyone, Matt Johnston here with another COVID-19 legal update. We're still in the midst, in a lot of places, of bringing employees back to work, and questions are starting to arise about how we go about doing that when dealing with employees who may need some sort of accommodation or who may be a little bit afraid or a little bit concerned about coming back to work. Now, I've said it many times, and government guidance is very clear on this, that simply because somebody is afraid of coming back to work is not sufficient reasons to not come back to work. Now, there may be some underlying medical conditions, there may be some conditions at home that make it difficult for an employee to come back, but simply fear is not going to be sufficient. So what happens if you do have a fear or an employee who has a fear of coming back? This is the time when you need to start listening. So one of the most important considerations that we are dealing with right now, particularly for small business owners, is what is the obligation of a business owner to accommodate the concerns, legitimate or not, of an employee who is wanting to come back to work but is fearful of doing so. So the first thing that I want to talk about is the law called the Americans with Disabilities Act. Most people have heard of this, but most people may be unaware of what the law actually says. So from a first step, the law itself, by its terms, says that it applies only to employers with 15 or more employees. Okay, so if you have 14 or fewer employees, technically the law does not apply to you. We're going to come back and address that technicality in just a couple of minutes. So if there is an employer with 15 or more employees, then the Americans with Disabilities Act requires accommodations for employees with a known or perceived disability. Okay, so known or perceived. So what does known mean? Known means the employer actually knows. Now, sometimes the disability is pretty obvious. Somebody who is missing their legs is disabled. All right, there's nothing, grand or, requires some sort of notice. If it is a perceived disability, this may be something that an employer sees but does not necessarily know in terms of having, actual knowledge from the employee. So again, you have these multiple sorts of things. So it's known or perceived disability. That known or perceived disability has to affect some of the activities of daily living and working. These can include everything from mobility to hearing, to the ability to handle or manipulate things, to going to the bathroom, to dressing, to eating, all of these sorts of things. It's a pretty broad description of what the activities of daily living are concerned. There is a medical description, but the law, the ADA does have a slightly broader definition, and it's anything that would affect that employee's ability to work. Okay, so a known or perceived disability that affects the employee's ability to work. Okay, so if there is those and there is a request by the employee to have an accommodation, employers are required to provide it. So that brings us to the question of what about a mental illness, anxiety, depression, something like that? These may be a disability, but may not be. Okay, and when it comes to COVID-19 and employees coming back to work, the existence of the disease and the virus and its impact on people can cause a spike in somebody's anxiety. It could create a situation where people are more anxious and therefore more prone to disruptions in their work. So a mental illness may be considered a disability. Now, all of these things are important when it comes to dealing with ADA covered employees, or employers rather. So if you have 15 or more employees, you're covered under the law. But what about for employers that are 14 or fewer? Technically, and by the terms of the statute, the law does not apply to you. However, there could be some state law implications dealing with disabilities, but there may also be some simple practical things as well. One of the most difficult things that I think employers are going to be facing, particularly small employers, bringing employees back is these concerns, is these underlying medical conditions. And it might be worth at least exploring the concepts of a interactive dialogue or an interactive process that we're going to explain in another video. This process is designed to come to and arrive at accommodations that are reasonable for the employee and the employer. Now, not all accommodations are created equal. In fact, if the accommodation request presents an undue burden on the employer, they are not required to provide that accommodation. So if the request is, let's take our person who's in a wheelchair, if the request is to, raise up the desk so the person can reach it, that's a reasonable accommodation. If the request is, some sort of high-tech version of a movable desk or something along those lines, that may be an undue burden. If the request is some special place to work, that may be an undue burden. So the undue burden is fact specific. It is this particular accommodation, does it create an undue cost, operational, structural, administrative, organizational change in how the business operates, and it becomes too difficult to accommodate, or it begins to affect other employees. So undue burden is a very fact-specific sort of thing. It doesn't have a straight definition. Here's what you should know from a practical standpoint. All employers, regardless of size, you do not have to sacrifice your business operations upon the altar of COVID-19 accommodations or any accommodations. Now, we're going to talk about in the next video what are some of the ground things that or sort of groundwork that you have to do before you begin the interactive process. And we're going to come up with that in just a moment. So that'll be in another video. In the meantime, if you want to have a discussion about the Americans with Disabilities Act, whether it applies to you or not, give us a call. We'll be happy to sit down and have a chat. Thank you very much.